I would like to call this meeting to order. Thank you for joining us during our weekly hybrid MLS breakfast meetings. My name is Lucy Morales, and I am your June program chair. Thank you. Reminder to please silence your phones. Okay, a little about me. My name is Lucy Morales with Century 21 Village Realty. I've been a licensed realtor since August of 2022. Prior to becoming a realtor, I worked as an administrative assistant for over 2 decades, specializing in sales, customer service, and office management. I am fluent in English and Spanish. I'm passionate about helping people. On my last transaction, I had the pleasure of assisting a very nice Taiwanese couple with limited English in buying their first home in California. When the opportunity came up, I wondered what to do. And guess what? Google Translate became my best friend, and I made it happen. Thank you. Before I welcome our guest speaker up to the podium, let me tell you a little bit about him. Attorney Raymond Zakari has been a local landlord tenant attorney for more than 20 years. He works at the law offices of Liddle and Liddle. Mr. Zakari is an accomplished trial and appellate attorney. He has argued cases at all appellate levels, including the California Supreme Court. Mr. Zakari is a leading expert in the area of landlord-tenant law. He is an adjunct professor at Mount Sac College, and he is also the co-director of the San Bernardino Riverside County Landlord-Tenant Bar Association. For nearly 20 years, Mr. Zakari has been volunteering his time with the Beverly Hills Police Department's Disaster Communication Services, DCS, as a licensed radio operator. Let's give a warm welcome to Attorney Raymond Zakari of Law Offices of Liddle and Liddle.
Good morning, everybody.
Good morning. Buenos dias.
Buenos dias. All right. Well, it's good to be here again. It's been quite a while. And as you know, I'm Raymond Zakari of Liddle and Liddle. Today, I'll be providing you with updates on local laws in San Gabriel Valley. I do want to mention that the California Supreme Court case was for one of the members in this room. So I've represented many of you before, and it's been a pleasure. We'll be going over the registration of properties and postings and serving tenant protection notices. Everything starts with where the property is located, okay? So I am unable to tell somebody what the law is related to their property without knowing where their property is. If somebody calls me and says, hey, I got a tenant not paying rent, we can get them out, right? Well, maybe. I won't know. By the way, there's no need to record because this is being recorded. It will be available. Also, the slides, don't worry about writing them down because we have packets of all the slides here. So you can come get them afterwards. There's we've copied about 90 of them, so you can have them and take them home with you. All right, so I need to know where the property is located. And why that's important is because local jurisdictions will pass their own laws and rules related to how properties are managed within that area. So, for example, what you can see on the screen now is you have red lines with blue lines. And what the red lines represent are incorporated cities. So for example, you have, you could pass them out. I have no problem with that. I think somebody wanted them up here, but pass them out if you want. What the red lines represent are the borders of the incorporated cities. So for example, here we have Monrovia, Arcadia, Glendora, Azusa, Baldwin Park, and so on. And then the blue lines represent unincorporated Los Angeles counties, okay? Unincorporated Los Angeles County has their own set of laws. And sometimes what we don't know is that for cities like Pasadena, the unincorporated county of Los Angeles is within what you would think is Pasadena. It has a Pasadena address, a Pasadena zip code, but doesn't follow Pasadena laws. And so the laws and the rules that apply to that property would be different than something that would be in the city of Pasadena proper, because Pasadena has its own laws. differences between the jurisdictions would be, the differences in the jurisdictions would determine whether you own interest on security deposit, whether you have to add a special addendum to the lease, whether you have to post certain notices on the property, whether you have to serve any termination notice onto the city or not. Okay. So here in San Gabriel Valley, we have various cities that have their own laws. We have Pasadena, Pomona, Baldwin Park, Claremont, unincorporated Los Angeles. All of these have their own set of rules and laws to follow. Okay. We've created this QR code, and you can check, just scan the QR code and you'll get the website to check your jurisdiction. The QR code will take you to the previous page, the previous slide that you just saw. All right. There's a difference between eviction control and rent control. And everybody seems to think that, oh, there's rent control, that's terrible. And unfortunately, it's the eviction control that creates more challenges for people. Rent control limits the amount of rent that you can increase on any specific tenant. Eviction control limits your reasons for getting your property back. Normally, we have eviction control and rent control together. And the reason why you want eviction control with rent control is so that you don't just get rid of a tenant under rent control and then raise the rent to market rent. So to prevent that from happening, to effectuate the purpose of rent control, they've created eviction control as well. Okay. What does that mean? That means you have, under eviction control, you have a limited number of reasons. And I think many of you remember that from the statewide rent control presentation. All right. Yeah. So in San Gabriel Valley, local jurisdictions, local cities, they require that we register our properties that are being rented to tenants. All right. And the types of information that they want to see are the number of rental units on the property. They want to know how much rent we're charging a tenant. They want to know what the current rent is and what the last rent increase is. They want to know the number of bedrooms. They want to know about parking information and who pays utilities. So listed here is the list of local jurisdictions that require registration. Pasadena does require registration of rental units. Unincorporated county requires registration. Baldwin Park requires registration. Okay. Pomona right now does not require you to register your unit, but they are requesting that you register your unit. So if you have property in Pomona, what you're going to get is a third party sending you an email saying, register your units. And it seems official, but it's not, there's no official law that requires you to register it yet, but they're going to come up with one. So there's no harm in registering it anyway. All right. I've created a link. These are QR codes with links to the registration pages, so that if you're managing property or own property in those jurisdictions, you'll be able to quickly find out whether you have to register your property in those jurisdictions. Okay. So if you notice from the beginning slide, first you determine where your property is, then you determine what you need to do. And with these QR codes, hopefully we can guide you to what you need to do as far as those properties are concerned. Okay, next slide. So I mentioned that there are lease addendums that are required by cities like Pasadena and Baldwin Park. And what they do is they require you to add a notice to the tenant at the inception of the tenancy to notify them of their rights under the local jurisdiction. There's also a requirement that you post these notices in common areas. It's a form that looks similar to what you see on the slide. And all you would do is you would attach it to your lease agreement, and you would, or hand it to your tenant. And this is your compliance with the local ordinances notification requirement. Okay. The city of Baldwin Park requires you to post the maximum allowable rent on the premises prior to issuing any rent increase. So what that means is, in the city of Baldwin Park, if you have not posted the maximum allowable rent increase allowed under that law, you may not raise the rent yet. You first have to do one before you do the other. Okay. By the way, we have seen laws kind of come and get more restrictive and more restrictive and more complicated. And that's why we do these presentations, is so you are up to date on what is happening. And they're changing regularly. And I'll be talking about statewide changes next. But right now, up on the screen, we have your rent increases for the various jurisdictions. We have Pasadena at 2.75, effective October 1st, 2023. We have Pomona's at 2.526. Baldwin Park is allowing a 3.9% rent increase. Unincorporated county allows a 4.275, although yesterday there was a vote that they're limiting the rent increases to 3% if you own more than 10 units and 4% if you own less than 10 units. Okay. Now keep in mind that if you own a property in the name of an LLC and you own another property in the name of another LLC and you control both LLCs, it's those LLCs that are determinative of whether you own the property or not. Okay, so it's not, it doesn't count as part of your 10 units just because you control the various number. Okay. All right. And under statewide law, it's 8.9% now for LA County, right? It was 8.8 last year and 8.9 starting August 1st. Do you remember statewide rent control? Do you remember that? Okay, when did that come into effect? Do you remember? Yeah, well, it came into effect January 1st, 2020. It was passed in 2019. So in September 2019, the state passed a statewide rent control that restricted the rights to evict a tenant and also limited the amount of rent you can increase. And they've made recent changes that went into effect. One of the changes went into effect April 1st. And that deals with one of the reasons to evict without cause. There's the one of them is the owner move-in. Okay, so even under statewide rent control, if the owner wanted to move into their property, they could evict a tenant as long as one of their family members was going to move in. So that was allowed. But now the requirement says that the family member or the owner of the property has to occupy the property for at least 12 consecutive months. Okay, that's a requirement. TPA stands for Tenant Protection Act. Tenant Protection Act is statewide rent control. Okay, people call it AB 1482. You might know it as AB 1482. You might know it as statewide rent control, but the official name given in the code is TPA for Tenant Protection Act. Okay, good question. Thank you. So there's changes with regards to how and the circumstances under which an owner moves in. And there's also changes to substantial renovations to the property. So starting April 1st, you know, everybody knows that, well, I just want to fix up my property and I can't do that with the tenant in possession. So I need to get the tenant to move out so that I could fix the property, right? I mean, that happens a lot. But that was being abused. And so the law's been changed. And now your notice to terminate a tenancy under that provision requires you to include special language. It requires you to produce permits, and it requires you to perform substantial work that affects one of the systems for a minimum of 30 days. And that cannot be performed safely with a tenant living in possession of the property. So, for example, maybe there's mold remediation. If this is a 5-bedroom property and only one of the bedrooms is affected by a mold, we could probably do the work in that one room without having to have the tenant vacate. But if it's a 2-bedroom property with 1 bathroom, and this is going to require extensive remediation that will make that bathroom inoperable and the bedroom inoperable for 30 days, then we could terminate the tenancy for substantial renovations. Okay. In that process, we would probably also upgrade one of the systems. You would have to get your permits in order. And once those permits are in order, we would present that all to the tenant along with the notice with the statutory language. One of the recent changes also created a penalty for failing to comply with the law. Previously, the rules were the rules without any specific penalty for failing to comply with the rules. Now they've included subsection 3, which says liabilities can include 1, actual damages, 2, attorney's fees to the other side, C, if done willfully or with oppression, fraud, or malice, up to 3 times actual damages and possible punitive damages. So what does that mean? That means, let's say we tell the tenant, hey, we're gonna substantially renovate the premises. And then they get out and we find somebody else to move in as-is condition, and we choose not to substantially renovate the premises, and we just rent it out to somebody else. That tenant could sue and recover those damages listed in the statute. And that might not be significant, but they also are entitled to potential attorney's fees pursuant to the statute, and that is significant. Attorney's fees routinely are higher than the damages that are awarded. Okay. All right. Exemption language. So it's been 4 years since the TPA was passed into law. And the most common mistake that we see at our office is the failure to check off the RCJC exemption box. Maybe a suggestion to CAR would be to make that box bigger, highlight it somehow. It's already in the center of page 1, but maybe make it bigger and bolded or something, because it requires you to check the box in order to exempt a property. Yep. Rent control just cause. And it's the rent control just cause. It's a rent cap and just cause addendum on the CAR library. And you'll find that. And for a single family home, as long as it's not owned by a REIT, by a real estate investment trust, or a corporation, and it's owned by an individual or an LLC without a corporate member, you might be exempt from statewide rent control. And if you are, you have to check that box for any new tenancies or create some sort of exemption language. All right. And so the purpose of this slide was just to remind everybody that you do have a CAR form that allows you to exempt these properties, but the box has to be checked or else it's not exempt, even though it could be. So it's kind of an opt-out of the Tenant Protection Act. But if you don't check the box at the inception of the tenancy, you'll be subject to it. All right. So there is a change coming to the security deposit laws starting July 1st. Many of you have heard about this. Current security deposit laws are what? 2 months. 2 months unfurnished, and if it's furnished, 3 months. The law's changing now to 1 month. Okay, so many of you are aware of the current laws, but the short version is, unless you're a natural person or an LLC with only natural members, meaning no corporate members of the LLC, and have no more than 4 units total. Okay. You can only charge 1 month security deposit. All right. Now, if you already have the security deposit in the amount of 2 months from before, you're okay. You don't have to return it. You just status quo. But moving forward, you can only charge 1 month security deposit unless you fall under the exemption. Okay. Existing tenants, okay. Existing tenants, you're okay. Yes. So first, not the last month. So first month's rent is not really a part of security deposit. That's just your first month's rent. So let's keep that out of the equation, because that's what you have to pay for the first month. The last month would be security. So that would be security. Yes. May you please repeat the part where you said only charge 1 month security deposit unless? Yeah, the unless part. Yeah. Okay. The so it is in the slide. So if you look at this slide on page 11, you will have the information, but I'm happy to go over it. Unless you are a natural person, which is just not a corporation, or if you are an LLC but don't have a corporate member, okay, and you own no more than 2 residential properties that altogether have 4 units, no more than that. So you can own 2 duplexes if you want. You can own a triplex and a single family home if you want, but it's 2 properties totaling 4 units. Okay, if you fall within that, then you are exempt of this 1 month rule. Okay, but otherwise you're limited to 1 month. This is a state law. If you live there,
Yep.
if you live there, you might have an exemption. I'm going to stick around for half hour at the end.
And then
Okay.
we'll also have a Q&A section coming up really fast.
Oh.
So if we can get through the slides, just hold on to your questions.
Okay, so she's asking to please hold on to the questions. There's a Q&A session coming up, but write down your questions because I'll answer them. And then even if I don't answer them as a group, I will stick around for another half hour. All right. There is an exception. If the tenant is a service member, a member of the military, then it's 1 month all the time, right? So there's a military rule that if they're a service member, you can only implement 1 month security deposit. Okay, so that's security deposit in a nutshell. Remember, certain jurisdictions have other rules with security deposits, like Pasadena requires you to pay interest on a tenant security deposit, Measure H. Sorry. All right. Landlord's failure to comply. So when a landlord fails to comply with any of these rules or ordinances, the tenant can raise in an eviction case that failure. So the affirmative defense in an eviction case, let's say for non-payment of rent, would be the landlord didn't register the unit. The landlord didn't serve me with a registration statement. The landlord didn't post the proper notices. Or I don't owe this amount of rent because the landlord never posted, let's say Baldwin Park, the landlord never posted the rent increase amount. So I wasn't required to pay that rent increase because they didn't comply with the laws. So those work as affirmative defenses in eviction cases. And then also there could be an affirmative lawsuit for failure to comply. As described in the prior slide, if a landlord does something in violation of the state law, there could be liability imposed by statute. So lots of rules, lots of things to cover, but not insurmountable. So if you start with the first slide, find out where your property is located, talk to an attorney, read the codes. There's probably 5 to 10 rules total for any given jurisdiction that's really important. You follow those, you'll be fine. All right. Thank you. It's been a pleasure. And I will open up to questions. And I'll start with you because I shortchanged you.
Okay, having a three residential unit, your personal residence where you live, and the 2 commercial rental unit, you qualify on exemption?
No, because it's 2 properties, maximum of 4 units. And if you have 3 residential properties, then you're already over the 2. Commercial doesn't count. Commercial doesn't qualify. So if you can have 10 commercial properties and have 2 residential properties and qualify. But if you have more residential properties, then that comes into the factor. But the commercial is not. You're exempt.
If anybody has any other questions, please come up to the podium. Thank you.
Hi.
When a tenant breaks the lease agreement terms by having extra persons with authorization, unauthorized pet, or destroying the property, I understand there's a basis for eviction. However, given these pro bono law firms, the eviction process could dilate tremendously and ultimately letting the tenant stay indefinitely. What's the point of a lease agreement? And 2, how can the landlords protect themselves from this?
All right. So I don't have to repeat the question because he's speaking into a microphone. So you all heard the question. Yes. And it's a great question. And it's more policy. It's more of a policy question. And I would encourage you to speak to your council members. I would encourage you to speak to your board of supervisors and let them know, hey, you know, when we enter into a contract at the inception of the tenancy, we do so and we negotiate terms, meaning the price, what I'm going to provide based on what's in the contract. When those terms and when the deal changes, I should be protected. I didn't negotiate those terms. And sometimes what happens is the city or the jurisdiction jumps in and says, well, you're too bad or you're stuck. For example, unincorporated county, they don't view an additional occupant as a material breach of the lease agreement, right? And that's a problem. Because when I rented this out to, I had a family of, let's say, or forget family, I had 3 people occupying a unit, and I cover utilities, and I rented it out for this price, and suddenly there's 10 people living there. And now my utility bill doesn't cover the rent. So I understand the concern. I'm not sure how to protect yourself from that, except to say that you need to be a voice in that discussion with your politicians because they do make rules. We challenge those rules routinely, but the change is slow.
Thank you.
With regards to pets, real quick, there's other considerations, and I'm sorry, I just want to.
That's one of the problems.
The pets, right? I'm going to tell you, pets. There's 2 things coming up. Statewide, we're going to get a law pretty soon that just nullifies that, like all tenants have a right to a pet. That's coming, and then also there's a federal law which allows emotional support animals. So if it's an ESA, they're entitled to a pet, and then your state legislatures are passing a law that allows tenants to have pets regardless of what the lease says.
On the, let's see, the tenant moving back, if they have demolition, can they move, you offer them to move back after a major renovation? Could they get the previous rent or you could charge them the current rent?
You don't have to rent it back to the tenant. It's only if you don't finish up the job.
No, you finish it up, then
You-
it says that you can offer them to have a right to reoccupy.
No, you can offer it at the new rent.
I see.
Yeah.
Thank you.
Sure.
Okay, regarding security and rent, if a potential tenant want to pay 6 months of rent upfront, can the landlord collect all 6 months?
There's an exception to the security deposit law, and I'll talk to you about that later because that is a different section of the code. So there is a 6-month rule within the code, and that's not what's contemplated in this 1 month, 2 month. Okay, so I'll talk to you about that separately.
Thank
Okay,
you.
because that's an in-depth conversation.
Hi, thank you for your presentation. Very informative. My question is, do you know of that law that's coming in effect in July?
The
in 2
security
months?
deposit?
No, it's a different one that makes it even harder to evict a tenant.
I don't
I
know which
can't
one it
remember
is.
what it is, but it alerted where there was a tenant that we'd like to evict.
Mhm.
So if we serve them a 60-day notice now, is it compliable? Or is it that 60 days has to
It
be
might have been that
completed before
April.
July?
It might have been the April rule, but I'm not sure what you're talking about.
I don't remember. I
but-
just, yeah.
But it generally, it's viewed that it's not when you serve the notice, it's when the notice expires.
Okay.
Yeah.
So it's so if it's
it's-
served now, it doesn't, it's,
No, because
can't
it's
be.
before, it won't expire till the end of July. And if the law's in effect July 1st, then you can't terminate in violation of the law at the end of July.
okay, thank
Yeah,
you.
You're welcome. I wanted to answer a little bit more detail the previous question with regards to the effect of evictions real quick before you ask your question. There, in the city of LA, there's a right to counsel in all evictions. So when you're evicting a tenant in the city of LA, it's likely that your tenant will have an attorney appointed to them. There are a number of nonprofit agencies. From every eviction case that's filed, a portion of that money goes to a fund that supports these nonprofit groups. Plus, there's federal, state, and county funding that goes to support these groups. And it's all done to kind of tip the scales a little bit to what they perceive to be more balanced. Unfortunately, the method of litigation and our court system can't handle the influx of litigation related to unlawful detainer cases. So routinely let's just use downtown LA as an example, cases are lasting 3, 6, 7, 8 months. And part of that is the jury demand. You get a jury demand, you're not going to get a jury maybe for a month or 2 months after you even get your first trial date. And at that point, you're already 2 months into it. Then the other problem we see is that even after, let's say you got your judgment for possession, it takes the sheriff another sometimes 4 to 8 weeks to get out to the property to conduct the lockout. And that's because they don't have enough people either. There's not enough officers to conduct the lockouts, and they're being apportioned and distributed to areas that affect health and safety, not really judgment enforcement. So that's part of the delay in the process. Go ahead.
Okay, so my question is, single-family property,
Okay.
unincorporated area of LA County.
Yes.
Owner wants to sell the property, tenants are in there. Can we have the buyout portion passed on to the buyer, or does the owner or landlord have to pay that buyout?
That's a good question. So, single family home, unincorporated, you still have potentially eviction control. So even though you don't have rent control because it's separately alienable under Costa-Hawkins, there's no rent control. They can still enforce eviction control. There is a buyout option. If you want to give a credit to the potential buyer for that, but the tenant has to agree to it.
The tenant has to agree to it.
Yeah, the tenant is not obligated to move. So,
Not a good idea to take the listing.
well, I'll talk to you about it. I'll be here.
Listing with owner living in the main house, renting out his garage and another bedroom, wants to sell. What type of notice has to be given to those type of tenants?
Okay, so there's a owner living in the main house and renting out the garage and another unit on the property. This is one of those situations where I would say, well, where's the property located? That's where I start my,
Covina.
but that's where I start my
Okay.
analysis to see what laws apply. And then another flag that went up is renting out the garage, and that's its own issue. So that would be a discussion because there might be exposure and liabilities, and so it's there'd be an approach. Not everything is this black and white hard approach. Sometimes you have to take a softer approach, or a measured approach, or a calculated and strategic approach to achieve your goal. One of those might be, hey, let's how you doing? Can we discuss your tenancy? This is what we're planning on doing. It's similar to a cash for key situation, but it would incorporate different forms.
So it's not going to be an easy fix.
It's not an easy fix. I think many landlord-tenant disputes are not easy fixes nowadays. So, but it's not an insurmountable situation. It happens all the time. So I'm happy to discuss that one with you,
Okay.
and spend some time on that.
Okay.
Okay.
Thank you.
Either, let's say a tenant has an ESA, but it's a dangerous breed.
Emotional support animal, dangerous breed. So pit bull.
Yeah.
Okay.
So it's like, so insurance could come into play as far as insuring that. Is it?
Yeah, I don't have an answer to that because that's always been my, the law says, I guess you're required to give a reasonable accommodation, right? And then, and is it reasonable not to have insurance on a property? No. And so there's a business and economic reason to deny the reasonable accommodation.
Yeah.
And maybe it's related to that, but there's a conflicting position on that. And the reason why I'm not committing in my response to you is because it doesn't take a lot to sue a landlord for a violation of that. And it takes a lot for a landlord to defend themselves in that situation. If the person suing the landlord loses, well, then they just lost, no big deal. But if they win, if the landlord loses, they would be required to pay the legal fees. That's on top of the legal fees that they paid their own attorneys to defend it.
Yeah.
So I would at the very minimum if you were to say, okay, I would at the very minimum have a documentation that the dog has never shown any signs of aggression, that they're licensed, that they've got their shots, things, and they'll comply with the rules.
Cool.
Last question.
Thank you. Hi, here, Sylvia Ramos. Great presentation. Appreciate you. Earlier, you caught yourself with the word family. Just in a generalization world, would you suggest to stay away from the word family in a tenant situation? Or, for example,
the reason why I didn't use the word, the example of family is because it could come under the federal and state protections for discrimination against familial status. So I didn't want to get into the example for that reason.
So in respect to that, have you encountered any situations with a fair housing violation using the word family?
I'm not sure what you mean by the use of the word family. Do
Okay.
you mean like in a lease agreement or
In
in
a-
rules or
Or
regulations?
let's just use realtors as an example. I'll use the realtors as an example. I made a phone call to a realtor, no one here. Realtor says on the other side, is your client have a family? Question number one. Number two,
Yeah, that's not an acceptable question.
and the other question, is your client have a wheelchair?
Yeah, obviously. Yeah.
The
those
other
are-
question, are they students?
Okay.
And the other question, do they have dogs? So it was all really bad.
Yeah, maybe send
Thank
them a note, say, hey, just FYI, there's a fair housing training. Here's the link.
Right. So I just wanted to get your intelligent response to that and in respect to the word family. I mean, there's so many changes, you know, from master bedrooms to primary bedrooms, the manhole, the people hole, you know, single family homes. Are they going to continue to be single family homes? Or are they just going to be called homes? Thank you.
Thank you so much. One really quick clarification. So for if the owner wants to move out in order to sell his property to list it, are they not allowed to do that unless the tenant agrees at all?
I'm going to answer that. I'm going to be vague as to my answer because this is being recorded, so we'll talk about it later. But I'm going to start with, it depends on where the property is located. That's kind of why I started the presentation is, where's your property located?
Riverside?
Riverside doesn't have that many restrictions. So-
Okay, good.
Okay.
All right, thank you. Thank you, everyone. Okay, thank you. That was awesome. Thank you.
Thank you.
On behalf of the West San Gabriel Valley Realtors, I would like to thank our guest for a very informative presentation. Thank you. Thank you, everyone, for joining our meeting today. Have a wonderful day. This meeting is now adjourned.